Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. You know, when a lawsuit is filed, the judge hearing the case must have the power to adjudicate the case. This is the original jurisdiction. And not only that, the judge must have the power to hear the matter before it. Put another way, the judge must have the power to hear a specific kind of case, and that's called subject matter jurisdiction. And when we're talking about the federal court, we're talking about another layer of jurisdiction, pendent jurisdiction. Pendent jurisdiction gives the original jurisdiction, the federal court, the power to hear a state claim, which is called our subject matter jurisdiction. Now, that's all good, but the fact that the plaintiff asserts pendent jurisdiction in their lawsuit, it could silence their state claim. And let me show you how. So let's get started. Pendent jurisdiction, also called supplemental jurisdiction, as I said earlier, gives federal courts the power to hear state law claims that it otherwise would not have power to hear. And you can read this at 28 USC section 1367. And why this limitation? Because federal courts exercise jurisdiction over cases involving one, the United States government, two, the Constitution or federal laws, or three, controversies between states or between the United States government and foreign governments. So let's illustrate. Plaintiff files an ADA claim, American with Disability Act claim, and a claim for infliction of emotional distress in the United States District Court, Eastern Michigan District. Because plaintiff asserted pendent jurisdiction in her complaint, the federal court has jurisdiction to hear plaintiff's infliction of emotional distress claim with her ADA claim. Thus, the district court now has subject matter jurisdiction over plaintiff's emotional distress claim. Again, subject matter jurisdiction is the requirement that a given court have power to hear the specific kind of claim that is brought to that court. And that's true whether it is a federal lawsuit or a lawsuit brought in the state court or superior court. And one more thing that is important in order for the federal court to assert jurisdiction over the plaintiff's state claim. There must be a common nucleus of operative facts. What are we talking about? A federal court can hear both federal and state law claims if they come from the same set of facts. Okay, let's say the judge rules against the plaintiff and dismisses plaintiff's ADA claim only. The district court has dismissed plaintiff's ADA claim over which it has original jurisdiction. Thus, the district court no longer has jurisdiction over plaintiff's infliction of emotional distress claim. Or does he or she? What do you think? Yes or no? Would the judge maintain subject matter jurisdiction over the emotional distress claim? Yes or no? And how would you rationalize that? What would you base it on? What legal principle would you argue to make your case? Well, hold your seat. The district court judge may decline to exercise pendent jurisdiction over plaintiff's infliction of emotional distress claim. Exactly. That was exactly my reaction, just like that. What? And my interpretation is whether the case has merit or not. Wow. So it becomes critical, pro se plaintiff, that you evaluate your case before you file the lawsuit. Before you file your lawsuit, know your facts and know the law that you are relying on. Now, remember, the facts should never change unless you just forgot something. The point I'm about to make is if you make a mistake with the law that you cited or some other material, fix it. You make mistakes. I've made mistakes. I still make mistakes, but I fix them. Now, it's important that you hear me on this because what I hear out there and I know about is that the defendant will file a motion to dismiss, for example, and they spell out that the plaintiff cited the wrong law or the wrong jurisdiction or whatever the case may be. Don't let that put a dent in your case or in your interest. You just fix it. Don't let it get you down. You just fix it. Don't let it intimidate you. You just fix it. How? You have to file leave to amend your complaint. You do that. Federal Rules of Civil Procedure 15. Just fix it, okay? And another thing to remember, in the interest of justice, the court must be liberal in allowing the plaintiff to amend the complaint. Know the strengths and weaknesses in your case. Determine if the state case is stronger than the federal case. It may be that the lawsuit needs to be filed in state court. Plaintiff, be careful about dismissing a federal claim with the expectation that the judge is going to hear your state claim. Well, as you just saw, there's no guarantee the judge would adjudicate your state claim. And I've seen this happen to plaintiffs. So be careful. There are 3 other reasons why the state claim not be heard and is silenced. And you'll find that in 28 USC Code Section 1367, paragraph C. So, while pendent jurisdiction is a powerful strategy, it could just as powerfully work against a state claim and silence the plaintiff's case, potentially forever. I trust this information has been helpful to you. Evaluate your case and find its strengths. I'm Advocate Lucinda, and we will see you next time. And remember, be empowered. Take care.